All right, I'm going to get us started. I'm John Haig. I'm the co-director of the Mostava Rahmani Center for Business and Government. It's great to see so many familiar faces here. The topic today is UK competition and consumer protection law. And at some level, you could kind of think of that as potentially a somewhat narrow topic. But in fact, it's a great analog to thinking about how you deal with major tech companies. And whether you think of them from the perspective of ex ante regulation, which is a very European approach, or an ex post kind of perspective once the harm's occurred, like you get in the United States with our competition policy, or what we refer to as antitrust policy. Um, we're very fortunate today. We have with us Gene Kimmelman. Uh, Tom Wheeler is here as well. I think many of you know all of us at this point. We've been doing these seminars for a while. I won't go into a lot of detail. Gene was served as Deputy Associate Attorney General and dealt with a lot of issues of antitrust and tax policy in the DOJ. He was president and CEO of Public Knowledge from 2014 to 2020. He's had a variety of other positions, which I won't go through in detail. He is currently a senior fellow, senior research fellow here at the center, as well as a senior policy fellow at Yale University's Tobin Economic Policy Center, working with many of the economists there. So I'm going to turn it over to Gene pretty quickly here. There's one thing I did want to mention, and that is that at this point in time, um, the world is in many ways very complicated. And we are seeing kind of activities probably that we maybe have never seen in the history of the United States. And more than ever, my philosophy is, and I think it's reasonable to say a center philosophy, is that having these discussions in open ways with transparency is particularly critical. And while we won't necessarily provide a center view, we as individuals will provide perspective and views. And I think this is an opportunity if you have questions, if you have points of view, to share those points of view with us, and we'll certainly be comfortable sharing our points of view with you. Um, so with that, Gene, I will turn it over to you.
Great. Thank you, John. Um, Thank you all for being here. And thank you, Harry Park, for helping me pull this together. Harry's going to work with me on walking you through some of this. So John mentioned a little bit about the law and how it's different than some of the other laws that we often look at in this area. But you may ask, like, why focus on the UK and this particular new piece of legislation? Small country, but I'm going to argue this is really, really important. Now, in the context of everything else going on in this country and geopolitically, maybe this isn't such a big deal. So just to place it, I'm not trying to overstate it here. We have so many more important things that are going on that matter to our lives. But this is important in some specific ways that I do think it makes it um, certainly not unimportant to look at. So let's do that. I'm going to go through a little bit about what the law is, the processes involved in it, how we got here, where it's situated vis-a-vis some of the other important things that are happening around the world. We have antitrust cases in the US. We have the European Commission moving forward with broad digital regulation through Digital Markets Act. Many other countries are looking at these things and following and making adjustments as we go. But I'll try to place this a little bit and then look at the preliminary activities of what is happening under this UK law and how that may be very important for the other things happening in the world. So that's our framework. So what is this law? John said it's not antitrust. That's absolutely true. There's nothing in this about uh, looking for market definitions and levels of concentration and specific legal standards related to uh, agreements or cartel behavior or anything like that. The agency overseeing the law, the Competition Markets Authority, is the antitrust authority in the UK. So they do all of that antitrust work separately. This is an additional authority given to them, an additional power. Um, and it's not regulation either. It's a hybrid because it is not about creating broad rulemakings. It's not about setting general standards across an industry sector. Um, it's a combination of some of the things that are used in antitrust, some of the tools that are used in regulation, and it has unique features. And I think it's particularly important because, as many of you know, Tom Wheeler and I, starting with Phil Revere, have argued for the creation of a digital regulatory agency in the US. Not very likely in this political climate, but we thought it made logical sense. I would argue this law is the closest to what we've seen of what a digital agency might be able to do coming at it from a slightly different direction. So we'll look at that. So how does it work? Um, we're looking here at a goal of promoting fair dealings in the marketplace for consumers and commercial partners in the marketplace, open choices, transparency, and trust in the marketplace. How does the law go about this? It focuses on specific companies and specific services and goes through a formulaic of whether the company slash service has strategic market significance, strategic market status in the UK. And then if it does, the CMA, the regulator here, the oversight body, is given the authority to impose conduct requirements on those companies for those specific services. It's also allowed to launch pro-competition interventions. So not just what is fair in the marketplace today, what is open and transparent, it gives you choice, but what might be necessary in the future to do that. And again, it's all to achieve this overarching goal. Now, what I think is most important about this is that unlike antitrust, there's no requirement of an evidentiary proceeding to find either wrongdoing or a particular harm to consumers or commercial partners in the past. I mean, you can look at those things as you do the analytics around what has strategic market status and what is fairness in the market, but there is no minimum requirement in terms of evidentiary fact finding, which is really rather unique. You can look forward at broader competitive needs, and you also must be proportional in how you do your regulation, whether it's the conduct remedies or the forward-looking competition opening requirements. It must be the least intervention necessary to achieve those fair dealings in the marketplace and transparency, openness, and choice. So this is kind of a unique structure that's being put in place. With this, the CMA is already, this was just kind of took effect like a month ago. The CMA has already launched a few investigations. So now we're going to look at those to see what they're doing here. Two major investigations, one involving strategic market status of Google in search. Not a surprise to anyone, knowing how large a presence Google has here, there, Europe, around the globe in the search marketplace. And then Google and Apple for their strategic market status in what they call the mobile ecosystem. Now here, effectively, what they're talking about is an ecosystem around this, whether it's the iPhone world or an Android world, the operating system, the browser, the apps, the app stores available through the device. So those are the initial investigations being launched. They have 9 months from the time of launch to reach a conclusion on strategic market status, make that designation. But here is, I think, the most important thing about this. It's not, we kind of are, we're going to walk through this a little bit and you'll see why it's kind of pretty straightforward. I don't think the ball game here is whether someone has strategic market status. We kind of know the companies they're looking at do. We're going to go through the elements of that. But what matters to me in the context of everything else happening in the world is that they simultaneously, as they're doing that, are looking at specific conduct requirements from the get-go. And they've already announced that they plan on announcing their preliminary results for strategic designation and conduct requirements approximately in June or July. Now, I say that's really important because, again, we'll talk a little bit more about the broader geopolitical winds that are blowing and who is being pressured by whom to do what or not do what. But these are preliminary, but they will have a full set of analytics as to why the CMA thinks certain things are necessary in order to achieve fair dealing in the UK marketplace. So let's break this down. Let's start looking at search. The search proceeding, again, how do you figure out if Google has strategic market status? Well, do they have entrenched substantial market power? Some of this is pretty straightforward. Most interesting thing here is the 5-year look ahead. Now, stop for a second. Antitrust is about misbehavior in the past and looking at market structure and looking at power of the market, concentration and whatnot. When you look at antitrust remedies, you do some forward looking because you're trying to remedy for the past and try to make sure the market is opened up to future competition. This is very specific, a 5-year look ahead as part of this analytics of whether you have strategic status. And they have specifically teed up how Google is using artificial intelligence, large language models, whether that is being added to its search prowess, whether it is adjacent or whether there are other things in the market happening that would diminish that power. Now, we come back to this when we get to the Google search case here, but part of the remedies deliberation here is this very issue, how to think about artificial intelligence. It wasn't really part of the case fact base that started more than a decade ago. So also in the search case, they have to look at all the other indicia of size, scale, the various forms of power Google has in the market. And they've preliminarily already picked out some possible realms for remedies. Access to default positions, Google's revenue sharing agreements in the Android ecosystem with manufacturers, with smartphone distributors, how Google has gained a dominant position in data and how they use that data, and whether they're kind of favoring themselves across their services to promote search dominance. So not surprising, these were the very issues that were being looked at in the Google search antitrust case here, and previously by the European Commission in some of its antitrust cases against Google. So what about the other investigation? Strategic market status in the mobile ecosystem. Again, think of your device, think of the various different functionalities on the device. Is there strategic status here? Well, the CMA, again, preliminarily has put this out with a sense that there is a possible duopoly, or there's two different markets adjacent to each other. Either you're picking an Android device or you're picking you're going into the Mac system, into the an Apple device, so you're in the iOS ecosystem. Now, this is important because in the first antitrust case against Apple's App Store practices that was brought by Epic Games, the judge in an antitrust ruling in California, Judge Rogers, found that they really were competing across these ecosystems. They were not separate monopolies. Here, it is being set up as if it's assumed, at least at the start, that they really are two different enormously powerful ecosystems adjacent to each other. And again, I think it's fairly obvious when you look at the factors, the size, the scale, the dependence of everyone who is app developer, everyone who is trying to build an alternative app store, everyone who is trying to distribute content through apps. The dependence on either Apple or Google is enormous. So I think you're already seeing, again, um, all the factors will fall into place pretty quickly for the CMA as they do their analysis of strategic market status. Um, so size, scale, again, all of this kind of really flows automatically. Um, so where would this lead if they do move forward with strategic market status? Well, again, they've identified some kind of preliminary areas they think are problematic, that require some sort of a conduct remedy, creating more payment options in the app stores or adjacent to the app stores, prohibiting possibly Google or Apple from requiring the use of their own payment systems, enabling the promotion of other app stores through either the Play Store or Apple's App Store, so that you can go to a different app store or linked on through the web to an alternative avenue for reaching apps and their content. They've identified problems with having to sync up with the operating system, either on the Android side or more particularly in Apple's case of setting very stringent technical standards, often for security reasons, but very limiting for opportunities for app developers to innovate. And again, to take their own content and link out. So they're looking at all of these things. All right, so those are the two investigations. So where do we think search is headed? Well, not surprisingly, based on what I just described to you, the CMA had already been looking at Google. They had launched an investigation in 2020. And let me just say one other thing about their investigations. They, as an antitrust authority, they have traditional antitrust powers, but under UK law, they have one rather unique power. They can do sector analyses, market studies, to look not at misbehavior, but look at levels of concentration in a market, impediments to entry, impediments to innovation, whether they're things that are structurally not functioning in a market. And they can actually call for a breakup of companies in those markets, dividing of assets in order to open up any particular sector to more competition. So there's this underlying power that they have. So they launched this report in 2020, and I think what they're teeing up here is that they're working from the report and then asking for further input from comments now, between now and when they make a final decision from the public, as to what has changed or not changed in these markets. But they find enormous barriers to entry and innovation, particularly related to Google paying billions of dollars to Apple for default position on the iPhone. Similarly, revenue sharing requirements that Google has with manufacturers and device distributors that give them preferential placement in the Android ecosystem. They preliminarily found that even when, through the European Commission's antitrust rulings, there were choice opportunities mandated for consumers to pick their own search engine, that the choice architecture was skewed, uh, not very user-friendly, and that it inevitably led to people staying with Google predominantly. They found substantial fault with the way that was designed. They find also that with Google's advantages through its sheer size in the data arena, that they were able to train their models in ways that no competitor could keep up with, that they had enormous data advantages, and the control of that data is problematic to competition. They've identified the click and query data as being important for any competitor to be able to build some alternative search engine and train and improve their own models. So lots of preliminary leaning in towards problems with Google search. So let's look at the mobile ecosystem. Similarly, there was a report in 2021 that the CMA had done, again, after a deep investigation in this area. And they find, as I mentioned before, that it's really a duopoly with adjacent markets, two different operating systems, and consumers not being able to easily move from one to the other. So they say this creates unbelievable advantages for both Google and Apple against any competitor who wants to build alternatives across any of the fundamental functions on your phone, the browser, the operating system, the app store, or any similar content distribution model on a phone. Nobody could really compete well. The two companies were setting the rules of the road. They were blocking competition. And here, most interestingly, um, they talk about this as kind of a market control ecosystem framework that is so deeply embedded now through our phones that it could require restructuring. So again, keep in mind, they have this underlying power to call for an industry restructuring. And they identified this in 2021, claiming that if you want innovation in app stores, if you want more competition, if you want clear transparency and openness of information flow for consumers, you may need to separate these services from the dominant companies who today control them. So this is something that I think we should just keep in mind is already the preliminary leaning of the CMA. And again, I raise all of this because I think some of the most important things we'll see coming out of this are going to happen by the summer. Pretty fast for any implementation of a new law. Even though it will be preliminary, I think you're going to see a lot of specifics there. So let's look at what they're considering for search. Be ready. Can you jump ahead to that? This is what they've already listed right up front. Things that may be conduct remedies to impose. Now, again, I want to just stop for a minute. In the Google search case here, Judge Mehta, talk about this a little bit more in a minute, has made a ruling of liability. The government has come in with a set of proposals. John Sallett is part of that for the state of Colorado with the Justice Department at his side, calling for a broad array of remedies. One of the lead ones they're looking at is prohibiting Google from making payments for a default position, prohibiting some of the revenue sharing engagement Google has in the Android ecosystem with manufacturers and device distributors that have tended to give preference to placement of Google search. This whole question of consumer awareness, choice, and effectiveness, choice architecture has been teed up as to whether there need to be certain kinds of choice screens mandated, and that they meet certain criteria that don't fall into the same pit or don't develop the same pitfalls that the European Commission ran into in its previous remedies. With the data advantage that the CMA has identified already, they're looking at whether they should require Google to share all their click and query data with competitors, whether they should require Google to enable everyone to use their web crawling, which is their kind of instantaneous way of grabbing all new information for updating searches that, again, they have an enormous advantage over everyone else with their size and scope and broad market share right now. Giving consumers more control over their data, which right now, as you probably know, across your device, once you're using Google services, they can use it across a variety of their services, and they can use all that information to help them better serve you, but also know a lot more about you and possibly steer you in certain ways. So trying to shift control back to the consumer there, ensuring that their search results aren't discriminatory. And one of the issues that has been very front and center has been how publishers feel like they're shortchanged in both the advertising portion of the search market, display advertising market, and search advertising, but also that their content is being exploited by the search engine itself, and they're not getting paid adequately for the value that they bring to the marketplace. So that's something the CMA has looked at, and then the actual auctioning process around advertising, whether it's transparent and whether it's fair. Again, issues that have been very much teed up by the publishers in the UK. So almost all of this is within the realm of what has been presented by the plaintiffs to Judge Mehta as possible forms of remedies in the Google search case here. Now, this does not include divestiture of either Android or the Chrome browser, but keep in mind, this is just what the CMA is required to and allowed to do as it makes the SMS designation within 9 months. It's not the end of what they can do. They can then go back, as I mentioned earlier, and propose pro-competitive adjustments. And they have this structural power as an underlying power in their authority. So this is just the beginning. So not everything that's in the search case is teed up here, but these issues are. So then let's look at what remedies have been kind of put forward preliminarily on the mobile ecosystem. So again, with this concern about the difficulty of switching between iOS and Android, they've raised the question about whether more can be done to make it easier to switch, but also more importantly, if you're considering switching, how you can easily port your data, transfer your data from one operating system to another. Again, looking for ways of limiting friction in the marketplace that's there. Looking for greater interoperability in this app environment. And again, this stems from a lot of app developers saying that they have to build to Google and Apple's specs. They can't innovate as they wish. They can't pick and choose elements of the software development that they think are more innovative and preferable. So this is trying to open all of that up so there'd be greater interoperability in each of those ecosystems. Eliminate any restrictions on access to the devices. And then this kind of goes through a whole litany here of you have your own payment system. You could have a way of linking out to your own website so that people can access you outside of the Play Store or the App Store. ability to promote another app store, even in the Play Store or App Store itself, prevent interference in the in-app options that are made available through the app stores, and addressing all the pricing and commissions issues which have been used by Google to draw people to exclusively use their services and their Play Store um, in that environment. And any other form of discrimination against app developers and app distributors have been teed up here. So these are a lot of the kinds of issues that were raised in the case I mentioned before, Epic versus Apple, most of which was dismissed, but not all of it. There was a finding of violation of California competition law for Apple refusing to allow Epic to steer customers out of the App Store. That's still being adjudicated on appeal and the details of it. So we don't have a precise manner in which that anti-steering requirement injunction is going to be implemented. But that is there, and then there is a Play Store ruling that we'll talk about in a minute too, that found Google monopolized the Play Store and is subject to injunctive relief coming out of that monopolization case. So these remedies preliminarily teed up for both the Play Store and Apple's App Store are very much still in the ballgame of litigation in the US and the Digital Market Act rules that are being developed. So with this, how do we expect the CMA to go forward if they see the world the way, let's say, Judge Mehta does? He's already found Google to be a monopoly and to have abused its power as a monopoly in search and part of the advertising market. He's identified specifically those exclusive default agreements with Apple for payment of more than $20 billion a year to get that preferential positioning. He's also identified the revenue sharing agreements with in the Android ecosystem as being a source of abuse of power to preference Google search on Android devices. So he indicates that the result of this is inflated prices for search ads, and that there is an enormous imbalance now in the market with Google dominating through its massive data, its extremely powerful brand, such that his preliminary findings with looking at liability were that even Microsoft could not really offer Apple enough money or a good enough product given Google's data advantage to be a possible alternative default search engine on the iPhone. So he's teed up this enormous advantage that needs to be somehow rectified. So pretty clear here that what the CMA is looking at is very much on target with what Judge Mehta found there. So then let's look at the Play Store case. This was a jury trial with Judge Donato proceeding over that, where the jury found that Google had monopolized the Play Store, had blocked competition and distribution, had used its revenue sharing to block competitors from growing in this environment or adjacent to the environment, and forcing app developers basically to use the Play Store in order to get any kind of revenue sharing or reasonable financial returns. So Judge Donato, taking those jury findings, has proposed an injunction for 3 years prohibiting Google from doing a number of things. Any of these kind of revenue sharing preferential relationships, any blocking of alternative payment systems through the Play Store, any suppression of advertising and promoting alternative app stores or driving consumers to use alternative websites to access app content. That is being appealed in the Ninth Circuit here, but those kinds of findings and proposed remedies, again, really sync up completely with what the CMA's preliminary thoughts are here. Well, then we have the European Commission, which is now 1 year into the implementation of the Digital Markets Act. So just to step back for a minute, just as a reminder, also, this is not antitrust. It's not a new regulatory agency, but it's a hybrid that has, unlike the UK's fairness standard, has very specific requirements of interoperability, prohibition on self-preferencing, not sharing data without consumers' consent, a variety of specific requirements on app stores to be interoperable, all dependent on the European Commission finding that a company is, number one, a gatekeeper with enormous market power, and any specific service offered by a gatekeeper is subject to regulation if it meets certain criteria under the DMA. And so these are specific services across a set of companies, not just individual companies like the UK law and an individual service looked at with general requirements. It's very specific requirements once you hit that trigger of being a gatekeeper with these powerful services. So that's the framework in Europe. It is supposed to be self-executing, and the companies are required to comply. And guess what? They're required to abide by the mandated behavioral requirements of the Commission in March of 2025. So right around the corner. So pursuant to that, the build up to this has been after being found to be gatekeepers with services subject to these stringent rules. What are the companies doing? So in Europe, the Commission has already found a few problems. Number one, it has found Google non-compliant related to search and Apple non-compliant related to its App Store duties. So they have specified that Apple must do more than what they have been proposing so far. The initial focus was on this question of whether you could steer consumers out from the App Store to an alternative App Store or to the open web or a particular website to be able to buy an app, different price, different payment system, whatever. They've found that Apple has not complied with that. Some determination could be coming very soon related to that. And they've also found that Apple has not been opening itself up to the interoperability requirements as specified in the law. And so they have just put out a kind of specification for compliance of a set of very stringent processes and sharing of information that Apple must do with app developers and other app stores in order to show that they are truly being responsive to the interconnection interoperability demands that are they're obligated to meet under the law. So that again could all be leading towards a fine or a penalty in the near future, or again, Apple may make changes to respond to this. In Google search, it just was announced that they are found to have not been meeting the self-preferencing prohibition in the law, that they are favoring certain kinds of search in certain ways, particularly vertical search, third parties, whether it's hotels, airlines, merchandise, whatever, and they need to make adjustments to meet the needs of the law in Europe. So again, these are all fairly consistent with the kinds of problems the CMA has been identifying in the UK. So let's think about this for a minute. Where does this leave us? All these things are bubbling around, and I'll talk in a minute about the broader geopolitics of it. But first, just kind of taking it straightforwardly, in June, the CMA goes forward and says, guess what? Google has strategic market status, Play Store and search. Apple has it in the App Store. And these are our preliminary conduct requirements. So everything we've been talking about, let's just assume for a minute that much of that is done out there in the public, and they'll reach a final decision in October of 2025. Well, where does that put us? Well, the Google search remedies proceeding is ongoing here before Judge Mehta. There will be filings in the next month or two and hearings in front of him. And he's indicated he is targeting a decision in August of 2025. So right here in June and July, he's going to have a bunch of CMA specific recommendations of how Google should share its data, how and if it should be allowed to have any default positioning. Maybe the answer is no, certainly not with Apple, certainly not with a payment. How and if they're allowed to do revenue sharing with Android device makers and distributors. Answer may be no, you can't, whatever. But it will be very specific preliminary recommendations. Click and query data, web indexing, how to do a choice screen well so that consumers can actually make a decent choice with understanding of what it is they're choosing. And that may sound very simple, but it's like how often, what is the sequencing of what your options are? When does it pop up? As you all know, most of the time you get these things popping up to you. Do you want cookies or not? Do you want your data shared or not? You're trying to do something, right? Maybe that isn't the moment when a company should be actually asking you a question because you know what you want to do and it's not answer that question, right? So you're going to just say, yes, I got to get past this, right? So there are different ways in which behavioral economists have come up with what you don't do in a choice architecture and what you maybe do that gives people really more of a thoughtful opportunity to make a selection. So all those kinds of things that are complicated, even though it's a simple idea, that a judge may have a really hard time sitting there and thinking, I'm doing this for this huge global company and I'm me and they have hundreds and thousands of lawyers and economists and marketing people. How am I going to do this? He may have the CMA walking through a whole logical set of how you actually impose certain behavioral requirements on companies as he's doing that. Maybe. Separately, the DMA, as I said, is being implemented, and it has certain specific requirements on interoperability and app stores and steering, and payments are being fought out. But the specifics in that law were drafted by the European Parliament. It is exactly what it says it is. Courts will interpret it, but it's not fairness and just broad transparency and choice requirements like the UK law. It's much more specific duties and obligations. What if they forgot one or didn't think about AI, which is in a separate law in Europe, but it wasn't really being debated front and center during the DMA? They can't really address it immediately. But the CMA might come up with something as it does its 5-year forward-looking projection and what is needed to make the ecosystem more fair and open to trading partners and to consumers in the future. And so there might be some things that are put on the table that the European Commission can't do right away, but could go back to Parliament and seek the power to expand, or could do part of, and maybe with the UK doing part of it, that will be helpful to move things forward. As this starts happening and we get some court rulings, there's the companies. What are they? They're getting regulated in different ways in different jurisdictions. I didn't mention Australia, but that's coming. There's India, there's South Korea, there's Canada, Japan, all looking at knockoffs of each of these models as ways of overseeing digital markets. Is there a chance that once things start happening one place, once maybe the CMA is quite specific, and they're supposed to be working with the parties and working with outside commoners, there's an open process in the UK, maybe there's some things that actually move in the marketplace. But I don't want to be too Pollyannish about this either. Let's step back and think about this political environment. What has been going on in this environment is first, this government threatening tariffs, countervailing trade penalties, has specifically teed up questions about whether Silicon Valley US companies are being discriminated against by Europeans imposing fines and even taxes, but certainly identifying the Digital Services Act and the Digital Markets Act as potential impediments to US companies. So there's a lot of at least huffing and puffing and maybe a lot more. There could be a lot of tariffs imposed if there are substantial penalties imposed on US companies. It's been targeted mostly at Europe, but I'm sure the UK is looking at this too, given how much trade there is between the two countries. So that geopolitical friction is a huge cloud over all of this. How does this play out? And the UK, the CMA just had its executive director fired by the Labour government. A lot of dispute about this. The new director worked for Amazon before. A lot of dispute about that. But what is clear is the government is saying we have an economic problem in the UK. We need to grow the economy. We need to be more. The CMA needs to be an important player in this. Needs to be actively involved in promoting commerce in the UK, jobs, new business opportunities. So it's being interpreted here as an enormous pressure on the CMA, possibly to not regulate too much. Now, some believe this is only limited to mergers and acquisitions, where the CMA in the past had been extremely aggressive blocking deals. But that's unclear. So when you look at the CMA's own environment at home, and you look at these geopolitical frictions, most of them emanating from the Trump administration, it's very unclear how this plays out, right? I mean, everything I just said may have some logic to it, but it is divorced from political reality. So we don't know how that works. But let me close my portion and leave you a few minutes to ask questions with one optimistic thought. As I said, to me, the key of what's happening in the UK right now is that there will be preliminary conduct requirements out in the summer. There's no penalty, there's no fine, there's nothing final about any of it. Could it have an impact on a judge in the US looking at similar issues related to Google in search, or the Play Store, or the App Store? Could it have an impact on what Judge Mehta is comfortable coming out with, knowing that there's a whole set of expert regulators who have been doing this work for decades, believe that similar things or exactly the same thing is required in their country? And if you get a ruling in the Google case on remedies that require some of these data sharing, payment system adjustments, default positioning, does that create a space for the Europeans to just piggyback on this? And does that create really the ultimate pressure on a global company to make some adjustments and then harmonize them around the world? I don't know. That's my optimistic note. I hope that's where we end up. Anyway, let me leave a little bit of time here for you to ask questions or comment.